Welcome to The Sound of Economics, the podcast series by Bruegel, the Brussels-based economic think tank. I'm Giuseppe Porcaro, Head of Outreach and Governance.
And I'm Guntram Wolff, the Director of Bruegel.
And we are pleased to host today Professor Franz Mayer from Belefield University, who is a jurist and expert of German constitutional law and European integration law. Welcome to The Sound of Economics, Herr Professor.
Welcome. Thanks for having me. Hello.
Today, we want to discuss the judgment pronounced by the Second Senate of the Federal Constitutional Court of Germany on several complaints directed against the public sector purchase program of the European Central Bank. The court found that the federal government and the German Bundestag violated the complainant's rights under the German Basic Law by failing to take steps challenging that the ECB, in its decision on the adoption and implementation of the PSPP, neither assessed nor substantiated that the measures provided for in these decisions satisfy the principles of proportionality. However, the Federal Constitutional Court did not find that the purchase program, also known commonly as quantitative easing, to be in violation of the prohibition from the EU Treaty of monetary financing of member states' budget. Also, the decision published today does not concern any financial assistance measures taken by the European Union or the ECB in the context of the current coronavirus crisis. I hope I've managed to summarize the main points of the ruling. However, as a non-expert of German constitutional law, I would like to ask Professor Mayer to explain us in more detail what exactly has been decided, and then we will discuss which are the consequences within the German debate and at the European level and in other member states. So, Professor Mayer, what exactly was decided by the German Constitutional Court and why?
Well, thank you again for having me and for having the opportunity to make a couple of remarks on what happened today in Karlsruhe. So I'm just to make that clear, I'm not speaking from Karlsruhe here, that's the green screen. And in a way, it's quite fitting that the green screen seems to kind of break down in a way that's fitting for the mood that most German constitutionalists who work on the EU as well will be in today. Because today is a sad day for European law. For European integration law, but also for German constitutionalism, because in a way what happened today was that the ego of judges prevailed, and that harms German legal and political interests in Europe. I would just state as in the beginning that what we saw today was an ultra-virus act, an act beyond legal powers, attributed to an institution, but not from the ECB or the ECJ, but from the German Constitutional Court in Karlsruhe. The German Constitutional Court, I would argue, overstepped the boundaries, the limits of its powers. So what was decided? It's really not that easy to summarize that. We have 235 recitals, 110 pages. German Constitutional Court decisions tend to be really narrative. So all I can do here, and I really ask, I have to apologize in advance if I'm oversimplifying things. So I can really only give a really very rough outline of things. And I guess this is one of those decisions, once more, that you have to read at least a couple of times before fully grasping all the details. I really hope that everybody that we operate under the understanding that all I'm saying is a preliminary assessment. Now, what we can say is that it was about the legality of the PSPP program, right? And the legality of the PSPP program of the ECB was checked, scrutinized under German constitutional law and under EU law by the German Constitutional Court. And all this at the end of a story, that started quite some time ago, because this entire case started more than 3 years ago, I guess, with a case introduced in Karlsruhe, going to Luxembourg, the European Court of Justice saying it's okay, this is legal. Going back to Karlsruhe reopening the procedure, holding an oral procedure, being very skeptical, and now issuing the decision this morning, finding that actually the ECJ had not properly applied the proportionality test, that thus the ECJ decision was irrelevant. That the ECJ the ECJ decision was thus not binding for the German Constitutional Court, and which allowed the German Constitutional Court to apply a proportionality test on the ECB lessons itself. So the ECB action, the PSPP program, was scrutinized by the German Constitutional Court to find that actually, according to their standards, the decision, the program was not proportional and thus illegal, being outside the boundaries of the powers of the ECB. They also talk about monetary financing, and they are not really happy with the way the ECJ scrutinized the monetary financing issue on PSPP, but at the end they say, well, that's kind of okay. That's not, in this part of the decision, they don't state that this is ultra virus. So I can briefly say something about the immediate consequences and the mid to long-term consequences. The immediate consequences that they clearly say the Bundesbank is not allowed to participate in the implementation of the PSPP program for the time being. And this actually applies to any German institution, as the PSPP program is supposed to be considered kind of inexistent in the German legal order. German institutions are not allowed to participate in any shape or form in the PSPP program. This also applies to some extent to the government and to parliament, to Bundestag and the federal government. They are required, and there they say, to take steps, whatever that means, to ensure that the ECB tries to make sure that this thing becomes proportional, or at least that we get some kind of demonstration that the ECB applies a proportionality test. And that's in a way what turns out to be maybe the small element of a good message in the entire decision. They say all this applies only after 3 months. They have some kind of a 3 months period where the Bundesbank could try to sort it out with the ECB, where the ECB could furnish their proportionality elements and kind of in a way repair what they consider to be a problem with PSPP. But then further consequences, of course, would be that the PEPP program, the corona-related program, would more or less, be scrutinized in very much the same way. That's pretty clear that the same people who brought PSPP to Karlsruhe would also go to Karlsruhe and challenge the legality of the PEPP program. And more generally speaking, it's pretty clear that the ECB would operate under the constraints and the legal scrutiny of the German Constitutional Court. At least that's what the German Constitutional Court thinks. So let me just give you a couple of elements of comment maybe and assessment, which are obviously pretty subjective and, my opinion. And clearly you will find lots of people who have other opinions, but still, well, the first element is that I guess they didn't anticipate that we would have this decision in the midst of a corona crisis. The way they presented the decision in some kind of introductory remarks by the president, which are not formally and technically part of the decision, illustrates that they are really not feeling comfortable with this kind of coincidence. So the president of the court said in his introductory statement, which is again not technically part of the decision this morning, that whatever they say about PSPP is not supposed to be addressed to current actions, which is on the one hand a good message. It's a good message, but on the other hand, it's actually legally not really sound. I mean, basically, what they decided on PSPP does apply to PEPP, and so there will be an issue. The more general comment that I would make is that, if you look at this thing, it's actually not really on PSPP. It's not really on the ECB, actually. It's basically addressed to the European Court of Justice. This is really a thing about judicial egos clashing, about judicial egoism. This is a story that has developed since the Maastricht decision in 1993. This idea of ultra-virus acts of the European institutions has always been, in reality, something about ultra-virus acts of the ECJ, this idea of who is the ultimate umpire, who is the final arbiter, who has the final word. And here we have the German Constitutional Court basically saying it's us. There's a lot of.
So Franz, can I on this point? Sure. Can I just on this point, because I think it's a very important. I mean, all the points you made are very important, but this point, I'm not sure everybody in Europe that is listening to us now understands even the term ultra virus. I mean, to me, and let's say of course I'm a German, so I know this stuff. But I mean, as an outsider, it sounds as if a regional court can just confront the legal order of the EU and actually undermine the legal order of the EU by saying, well, the ultimate interpretation of the European treaties is done by a national or regional court instead of the European Court of Justice. And, I just to read from the declaration of the Bundesverfassungsgericht, the German Constitutional Court of this morning, I mean, just to give you a sense of the language that is used here, also our listeners a sense. I mean, I quote here from the English version: the review undertaken by the European Court of Justice with regard to whether or not the ECB decision on the PSBP satisfy the principle of proportionality is not comprehensible. That's what they say. So basically, I mean, you say it's ego of a national judge, but it seems to me the consequences of this for the European legal order are quite significant. I mean, what will we say now to a Polish judge that will say, oh, by the way, the ECJ ruling does not apply to the way we deal with judges in Poland? I mean, so aren't the consequences of this for the legal integrity of the EU, aren't they enormous?
Of course, it's a huge problem, and it's always been a huge problem, this claim that under certain circumstances, a national court can kind of overrule the European Court of Justice. It's, in terms of logical reasoning, it's also clear that you can tell this story two ways. You can tell it from a national legal order, and then you can kind of end up with this conclusion that it's ultimately the national legal order that has the ultimate say. If you look at it from the European legal order, it's absolutely clear that the treaties don't provide for this kind of overruling of the ECJ. There's an Article 344 in the Treaty on Functioning the European Union, which basically says that the member states agree that if there's any problem of interpretation of EU law, they will only solve this problem in the way they agree upon. And the way they agreed upon is there is the European Court of Justice with its role and function under Article 19 of the Treaty on European Union. And if there is a national court challenging this is basically a case for treaty infringement. And this is really what I would see coming now. Actually, the ECJ, the European Legal Order, the European Commission, all legal players involved at the EU level, there is almost no other option than to really basically sort this out the formal way, because otherwise you will have a fully opened box, a Pandora's box. Some commentators think that what happened today was already the opening of the box. And as you correctly pointed out, there's Poland, there's Hungary, but in particular Poland, where you will, of course, turn to this kind of argument from the German Constitutional Court just to use it to say, here, look, even the Germans do it. We don't have to obey European legal claims of primacy or supremacy of EU law. And so this is really catastrophic. What is likely is la guerre des juges, the war of the judges, because the ECJ must react. It's a matter of kind of survival for the European Court of Justice. They can't let this just happen. And they have been pretty tough on courts of last resort of the national order in the member states recently. The Conseil d'État, for example, got this a message that they violated EU law for not submitting a preliminary reference. So there was a treaty infringement. The Conseil d'État didn't really like that. But it's happened before. It's happened before in other member states as well, in Scandinavian states, where the ECJ was willing to say what the court of last resort in those member states did, or what they said, or what they didn't do, was a treaty infringement, and they hold the member states responsible. But of course, this kind of war of judges is it's typically a war where you, as often in wars, you will not have any winner. This will have losers on all sides, and that's why it's so tragic.
I have a question from the audience, which is linked a little bit on what we are discussing right now. Odret is asking, in the OMT ruling, Karlsruhe asked a so-called preliminary question to the European Court of Justice in order to interpret the treaty. Why didn't they do the same thing this time?
Well, they did do it. This is at the end of a preliminary reference procedure. And if you go back in time, this entire story of the ultra-virus acts, so this legal acts of the European institutions that they would consider to be beyond the powers transferred to the European level, this is something that goes back to the Maastricht decision, where they invented this kind of. And then many years there was just not much happening, and then in 2009 in the Lisbon case on the Treaty of Lisbon, they kind of reanimated this doctrine of ultra-virus, and that the German public and the general public was hugely critical. So 1 year later, they in the Honeywell decision, they basically stepped back and said, well, actually, we still stick to this ultra-virus claim that we have the power to overrule, inter alia, the European Court of Justice. But if we ever do that, we would first seek the opinion of the European Court of Justice and give him kind of the possibility to explain. And so that's what happened here. They submitted a preliminary reference, in this case, PSPP. They didn't like the answer, and now they decided that it was ultra-virus, that it was ultra-virus. And again, it's a lot about judicial egos. You know, some people say what really happened is that they just didn't really like the way the ECJ answered their preliminary reference in the PSPP case. It's basically some kind of response to a perceived neglect by the European Court of Justice. This idea that from their perspective it was a big deal to submit preliminary references. So it's only the second preliminary reference in the history of the European Court of Justice and the German Constitutional Court. So and the first one was OMT, and now the second one kind of completely derailed.
Can we zoom in a bit on the consequences and understand a bit more what was actually decided? So on the one hand, the court says it doesn't look like monetary financing. On the other hand, it says the ECB, neither the ECB nor the European Court of Justice have assessed the proportionality and the side effects of quantitative easing. I mean, my first reaction when I read this is that, of course, judges haven't assessed it because they can't. I mean, it's outside of their competence. But to claim that the ECB hasn't assessed these consequences, to me, is just a sign that they have no clue of what a central bank is doing. I mean, central banks do these kind of assessments on a continuous basis with a whole load of models and empirical and theoretical analysis. So this assessment is being done, and they asked then that the ECB should now explain in the next 3 months why this is actually a proportional action. So why the PSPP program actually does make sense to achieve the primary mandate of the ECB. Isabel Schnabel, the German ECB governing council member, has been to Karlsruhe a few weeks ago and has explained in quite some detail why PSPP actually does make sense and does fulfill a monetary policy purpose of achieving the inflation target. So there has been long explanations by her. There's lots of papers published. What else can the ECB do? Should the ECB do? And does it actually stand a chance to explain and that what it does actually does make sense? And whom does the ECB actually have to convince now? Is it the Bundesverfassungsgericht that will then receive all the models and all the assessments from the ECB and then say, oh, finally, it makes sense what you are doing. It does actually have an influence on inflation. Or, I mean, how is this this 3 months period now gonna look like practically? If you can give us some insights from your point of view on this.
Well, I guess there's really a number of things that you can say on the points you just raised. The first thing is that it's probably quite likely that the ECB, although they will not really like it, they will try to issue some kind of, a more substantive proportionality test. And then we will see how this will go on. Of course, it's not really unlikely that the same people who brought this initial case to Karlsruhe will just go back to Karlsruhe because, again, my reading of this is, for them, it's not really a concern of this particular program. The people who brought this to Karlsruhe are Euro and EU skeptics, and so they will just try to go back to Karlsruhe just for in order to have more publicity and all that. So it's quite sure that the Council will probably address this again. But I would expect them to be rather generous on whatever the ECB will, if the ECB tries in a way to follow kind of their lead, that would already be a huge success for them to some respect. And so I would expect them to be rather generous. And again, we have to see that one of the judges, the president actually, will leave the court. So the court next time will be tomorrow, actually. It was his last decision. I don't think it's a good exit, but okay, his choice. The next time the court will have to decide on this, it will be slightly different. So there's one judge being replaced, but I'm not really too optimistic that whoever comes to replace Voskuhle will be that much more open to understanding what this is all about in the ECB and European integration, etc. And again, one judge is just one judge of 8, so that's not really much. Then your question, what really do they expect? Well, probably one thing that one should also know and see is that proportionality is just the core concept of German constitutional law. So in a way, basically everything in German constitutional law, ultimately ends in this kind of proportionality argument and this kind of balancing thing between different values at stake. And this is where the approach of the German Constitutional Court in this decision really becomes problematic, because if it's about balancing different interests, it's clearly a problem if you give a national court, the German Constitutional Court, this role, because by definition, the German Constitutional Court will have a German perspective, and it will be a very limited perspective. And the ECB, by definition, that's its task, will have a European perspective. And that's why the ECB should do this balancing test and not the German Constitutional Court. But that also means that ultimately, it's pretty clear that they will not really come to similar results when applying a proportionality test, because they will just kind of use different elements for the balancing. And that's the huge, I guess, the logical gap in their entire reasoning, that they believe that what they see is what everybody else sees. So they see a problem with the German real estate market. They see a problem with the German, I don't know, the house owners, the people, who try to make sense of their savings here in Germany, and they would have wanted the ECB to really take this seriously into consideration, to give it some way to balance it against all the other things at stake. But from the perspective of the ECB, this is just one tiny, well, probably not tiny, but just one element in a huge, complicated field of elements that have to be taken into consideration. And Guntram, I totally agree with you. It's totally absurd to think that the ECB didn't reflect on what the consequences of that would be. And it's in a way also a clash of cultures between lawyers and economists, of course. And that's something that was pretty visible in the oral procedure last year on the after the case came back from Luxembourg. They reopened the procedure and they had a hearing in Karlsruhe. And that was just, a textbook example of how lawyers and economists live on different planets. And then here we have a case of lawyers trying in a way to interfere in something which ultimately, of course, there is a legal framework. Yes, agreed. But it's something that belongs to the world of economics. And the sound answer, and that's something that I personally have been arguing since 2011, when I was counsel for the German parliament in the very first Euro case concerning the aid accorded to Greece. And I argued this is about judicial self-restraint, but the moment I argued that in the oral procedure in 2011 in court, I saw kind of, the faces of the judges kind of closing. They didn't want to hear about that. Judicial self-restraint was definitely not their thing. And that's really visible in that case here.
Professor, I have a question from Gregory, who said, but should the ECB enter that game with the German constitutional court and answer them on proportionality and risk opening the Pandora box as mentioned? It's a little bit like, should the ECB really do that?
It's a big question. We had OMT, and there the ECB agreed to appear in the case. So they took part in the oral proceeding. They explained. I was not sure at the time whether that was really the good approach, because, as I'm saying, the playing field of the ECB is the Eurozone and not one member state, and the concerns of one member state and the limited view of one member state on the world. And in a way, I found it logical that in the PSPP case, they didn't appear in the proceedings. They just wouldn't participate. They left it to the Bundesbank to argue the central bank perspective. Now, there again, it's a lot about psychology, on egos, and on this kind of thing. It was really, at the oral hearings, you could feel how the judges, they just didn't, appreciate the ECB just not showing up and leaving it all to the Bundesbank, which put the Bundesbank in the bizarre position that they have to defend a position that actually they themselves are critical of when it comes to the ECB. But my perception was they did a pretty fair job there. So now it's a little bit exactly this situation, should they, play the game and respond and say, okay, understood, we'll do a proportionality test, or should they just ignore them and find a way to pursue PSPP, without the Bundesbank, if that is even necessary, on the very technical level, and just, say this is not our playing field, let that court just have their thing. And in a way, it's probably a pragmatic approach would say, well, let them, they want to have a proportionality test and see that we have some ideas of what consequences are. And again, Guntram, as you say, it's pretty sure and clear that they do have this kind of reflection somewhere on file. So I guess they will pursue a pragmatic approach. And again, if I'm correct, that it's basically a fight against, between the German Constitutional Court and the European Court of Justice, the ECB will ultimately not really harm their standing.
Can we just zoom in a bit on the ECB and the Euro system? I mean, of course, the Bundesbank is part of the Euro system, the German central bank, and as a German central bank, it is a German institution, so it is subject to what the German Constitutional Court is saying. But at the same time, it's part of the Euro system and is therefore supposed has so far always implemented ECB decisions that were taken in the governing council, even if the Bundesbank governor Jens Weidmann or his predecessors did not agree with the governing council decision. Once the decision was taken in the governing council, it has always implemented the decision in terms of monetary policy decisions. Now we have this, as we just discussed, this clash between two different legal systems, between two different courts. How will this clash affect the Bundesbank's position in this game? I mean, at what stage will they have to stop actually implementing joint ECB decisions, and at what stage is the singleness of ECB monetary policy actually endangered?
Yeah, again, it's a good question. Well, on the very technical level, again, the German Constitutional Court said, well, we'll give you 3 months to sort it out. So they call it a transition period or something. So there are 3 months where basically the Bundesbank can basically go on as if the decision never happened. And again, I would expect that all players involved at the central bank level will try to find a pragmatic solution and not let it come to the point where the Bundesbank really has to kind of, in terms of loyalty, declare that its loyalties lie with the German constitutional order or that the loyalty lies with the Euro system. They will try to avoid this kind of either-or situation. But on a theoretical and maybe in the future not that theoretical level, it's true. It's a decision that at some point they would have to make. And that's in a way not a bug, but it's a feature of the system. I mean, that's the whole idea of it, that you're part of, two levels of monetary governance. And again, in a way, the mere fact to put the Bundesbank in this kind of impossible decision is taken alone. It's something that this decision of the German Constitutional Court must be really, critiqued for.
So let me push you one more a bit more into even extremer territory. So suppose the Bundesbank follows the German court because it's a German institution and because Jens Weidmann personally even thinks that's the right thing to do, and the ECB as an institution just decides to take over the things that normally the Bundesbank would do. I mean, so basically the ECB can go on the bond markets and buy German bonds in proportion to, and even decide, the governing council could even decide that from now on, since the national road doesn't work, the ECB as the European institution buys sovereign debts of all its member states, all the Eurozone member states, according to capital key, and also as the PEP. In the PEP program, this 33% issuer limit has also been scrapped. So they just go ahead and do this centrally out of Frankfurt, not out of the Bundesbank, but out of this Ostende, the eastern end of Frankfurt. What happens? I mean, what can the Bundesverfassungsgericht, the German Constitutional Court, really do at that stage? I mean, okay, they can call on Berlin to raise concerns. Berlin raises concerns, fine, but the ECB governing council just continues, and the ECB just continues doing its job. So at the end of the day, what's the end game here? Where can this end from a legal point of view?
Yeah, again, this is one of the big questions that obviously, as it concerns the future, I don't really have a sure answer for. But it points again to the basic flaw of the entire reasoning. The ECB is independent, and it's supposed to be independent. It's not a bug, it's a feature. The Germans wanted it to be independent like this, and it doesn't really make sense to come up with this kind of legalese frameworking of an independent institution. And if you really think this through, they didn't. On the surface, the trick is that they say this is unconstitutional, meaning it's kind of in conflict with German constitutional law. But they also make a statement about the legality under EU law. They basically also say this is violating EU law, and this is, of course, it's highly destabilizing, because this is not only by kind of a thing between the German legal order and the EU legal order, but this is basically saying that this act is kind of it's ill, it's not it's not sound. Also in the relationship of the EU legal order with all the other member states' legal order, this has some kind of 360-degree effect, and this is so dangerous. And if you think this through, could it really be conceivable that Germany participates in some endeavor where one of the main institutions keeps, that would be the perspective, illegal acts, I'm not, and you said it as well, I'm not really sure whether they really grasp, the kind of consequences of what they are doing here. But saying that parts of the ECB governance action is illegal under the rules of the ECB governance system of EU law is really a highly dangerous thing. And if they, if they really stick to their perspective, this would ultimately also mean that it remains in violation of German constitutional law, which in a way is also something that you couldn't kind of say, well, let's live with it, which ultimately you would have to solve this somehow. Well, in their perspective, how can you solve this? I mean, you can change the rules. You can change the rules of EU law. You can change the treaties.
Yeah.
You can change the rules of German constitutional law, and both is not really easy. And the other option is change behavior, change action. Don't do this anymore. And there again, you would have a lot of not only economists, just a lot of people saying, well, but that's what the ECB, in a way, in some situations, is supposed to do. So there is no clear way out of this. And this remains a huge risk, and in that sense, an unstable situation.
I think it's probably fair, Giuseppe, you will ask a question, but I mean, just to give my comment on this, I mean, my sense is that the ruling is so big, and as you say, it's 110 pages. We will have to read it more than once to fully digest it. But I think my sense is the ruling is so big that this whole issue of EU treaty reform and what the Eurozone will do with itself, will it create some fiscal counterpart to the ECB, and will we see also a change of the mandate and the scope of what the ECB can or cannot do? I mean, I think that this, at the end of the day, I think this will be back on the table rather sooner than later. So the question of EU treaty reform, getting a fiscal counterpart to the ECB, it seems to me it's been in the discussion for many years, and the Bundesverfassungsgericht, the German Constitutional Court, pushes that discussion and forces us to reconsider this option actually much more strongly than before.
Yeah, I would like also to read some of the questions from the audience. Especially, I will bundle a couple of them because they go exactly in that direction of the discussion. First of all, the direction of the debate around the treaty, and is there a reopening of the issue about the treaty, likely or not likely in the medium term as a consequence of this kind of rule or this kind of judgment, which is exactly what Guntram has just hinted. And another question that is floating around is if this sort of ruling is playing to the objectives of those who wish to wage a high-profile political war in Germany, in brackets, against the euro. And then I have also a question, let's say, from a southerner perspective about what is the consequence in the immediate term, and perhaps this a little bit more concrete of this ruling in terms of the quantitative easing program, especially indeed from the perspective of a country of the South that might be benefiting of this program right now.
Well, first on the treaties, there's an additional problem, and you see there are lots of problems out there, but the additional problem with this entire saga of the German Constitutional Court being Eurosceptic is that the way they set up their argument, it's not easy to overcome with treaty change or constitutional law change, because they locate the starting point of their argument in the democracy principle of the German constitution in a way that you can't overcome this by constitutional amendment. So where in other member states, like say France, if you change the treaties and then the Conseil Constitutionnel finds out there's a problem with the French constitution here, they can change the French constitution more or less without any problem. And without going into the details, because the details are really tricky, and that's, again, part of the problem, that it's such a complicated line of thought that they have here. But the way they set this up, it's not even the two-third majority in German parliaments that will be able to change this. And this is, of course, a huge problem. So I would still argue that treaty change...
sorry to interrupt. Why so?
Because you may find out that you consider treaty change that is not compatible with the German constitution as it stands, and that could only happen if the Germans gave themselves a new constitution.
Yeah, but why it's not possible to change the German constitution, as all the constitutions have been changed, as you've been pointing out? Other member states changed their constitution in order to fulfill the EU treaties.
Yeah, but you have a provision in the German constitution which says that some basic core elements of the German constitution cannot be amended. It's a consequence of the German constitution being a post-dictatorship constitution. So in 1949, the founders of the German constitutional order in 1949 didn't really trust their fellow Germans, and they put kind of, safeguards into the text that basically mean that there are certain things that you cannot overcome by amending the constitution. You can always just make a new constitution, but remember, Germany didn't even get a new constitution after reunification. So a completely new constitution for Germany would be a major step. So this is really a big problem with the German Constitutional Court, kind of linking all kinds of things to this kind of core, which cannot be amended. And this is in legal terms, and then obviously also in political terms, because the politicians know about that, and they can keep saying that certain treaty amendments are a no-starter because there's this thing about the German constitution that cannot be amended. So this is a huge problem. The second thing about how will this play out in Germany? Well, again, this is as many questions nowadays that concern politics, a really open question, which will also depend on how the post-corona order in the European Union will look like, whether there's really this kind of fallback to a more nationalist approach of things, or if it will be the opposite, that the lesson that we all learn is that we need more multilateralism, and in that sense also even more European integration. We will see. I'm not really sure, although they claim to do that the German Constitutional Court really speaks for the silent majority of Germans. That was one of the standard arguments that you often hear the judges speaking or writing extrajudicially in newspaper interviews or so. They say, we defend, the ordinary Germans' view, skepticism on the euro. We don't want to pay for the Southerners. This kind of crude populist argument that brought us the right-wing populists, the AfD. So I still believe that the majority of Germans is not really in sync with this kind of skepticism. This is a very particular thing with individual judges. Well, and as far as quantitative easing is concerned, well, as I said, the short-term consequences are very limited. And again, I'm pretty sure that the ECB and the ECB system, they will try to find a pragmatic way to move on. And that's probably one of the few positive aspects of these days. I mean, the immediate danger of a total breakdown of the euro system is just not there. There's a lot of symbolism, there's a lot of language, and Guntram, you said it, it's a long decision and we'll have to dig through it. Unfortunately, there's no dissenting opinion, although the decision was taken 7-1. So there was one judge who was not, who didn't want to vote for this decision. And they can issue, the judges in that case, a dissenting opinion, but they're not obliged to. But I would have liked to see a dissenting opinion, because that would have shown the alternative approach. I mean, assuming that the dissenter was more, in line with the pro-European argument and not even more nationalistic than the 7 others. Of course, that we don't know. But so that's a missed opportunity. But I repeat myself, this was not the last decision coming from Karlsruhe. So there will be more opportunities either for really good decisions or at least for good dissenting opinions.
Thank you. And Guntram, do you want to have some last reflection before we close this episode?
No, indeed. I think this was a great discussion, and I perhaps just want to end on this observation why this fiscal union discussion will become more important now. I think the reason is really that one way or another, what Karlsruhe has done will limit directly or indirectly the action room of the ECB. We have discussed today how much that action room will be reduced, and I think this is still an ongoing debate. We don't know yet the full consequences, I think, and financial markets so far have taken it relatively moderately. I mean, we've seen an increase in spreads somewhat, but not a very big increase in spreads since the ruling was announced. So the full impact on the capacity of the ECB to do its job of really looking after the Eurozone economy, the inflation in the Eurozone economy, support the financial markets in the monetary transmission mechanism, this will be constrained. But if it's constrained to a significant extent, then the issue of having a Eurozone safe asset that's issued by Eurozone governments, not individually, but collectively through some sort of a Eurozone treasury, to actually complete financial markets and have a more stable financial system, will be fully back on the table. And so ultimately, I think this ruling pushes us to accelerate that discussion, because typically monetary unions survive with a fiscal union, and a fiscal union means that you have to get the political union right, and then you basically have to agree on basic political principles of accountability, of decision-making powers, of also order, of legal order. And so this discussion, I think, is a discussion that was there, and I think it will come back with stronger force because of this ruling of the ECJ, of the European Court of Justice.
And indeed, this discussion will continue, and we at Bruegel, we are going to continue monitoring it and engage within this discussion, not only through our events and podcasts, but as well with our analysis that you can read on our website, www.bruegel.org. And on this note, I would like to thank all our listeners for having engaged in this conversation. I would like to thank Professor Mayer and Guntram for their contribution to the discussion today. And until next time, thank you. Bye-bye.